One of the things that I've been fortunate to witness is in March of 2007, the state of New York revamped the workers' compensation law in New York. And one of the things that they required was that there would be presumptive approval of diagnostic tests ordered by treating physicians for injured workers. If the cost of the examination or the diagnostic test or procedure was less than $1,000 in the state of New York, it must be approved in the workers' compensation system unless the self-insured employer or insurance company can provide an opinion why it's inappropriate. The opinion has to be provided within 30 days, or the request for authorization is deemed allowed as a matter of law. It will be paid for in the workers' comp system. And so what we immediately saw happen was actually benefits were being rushed to injured workers in a way that they hadn't been before. And an MRI, for example, that used to cost $1,200, the imaging company took the cost of that MRI and ran it down to $999.99 because it would be presumptively approved. The cost of the medical care became lower, and the injured workers were having to wait less time to get MRIs, CAT scans, other types of diagnostic procedures, including nerve conduction studies or other things that test the nervous system. In the state of Washington right now, we have a system where the treating provider literally has to beg the Department of Labor and Industries or the self-insured employer. They have to say, look, I'm an orthopedic surgeon and this person needs a shoulder MRI. And then the department disapproves it. And then the injured worker gets upset and goes to an attorney, and the attorney says, okay, well, they've disapproved once already, but why don't we get another doctor to take a look at you? I had one injured worker who had 3 separate orthopedic surgeons say he needed an MRI of his shoulder, and then we had to go to the Board of Industrial Insurance Appeals about it before the department relented and authorized the MRI. Turns out his shoulder was as messed up as all 3 orthopedic surgeons thought it was, but my guy went without care for months. When you delay care for injured workers because you're being petty with your authorizations and you're second-guessing every single thing that the treating providers are out there in the noble cause of providing this medicine that they practice every day, if you second-guess them and deny care to injured workers, you just make the problems worse. People don't get the care they need. They fall into depression. They don't get to rehab with the same potentials as other people who got treated faster. And then the vicious cycle starts, whereby all of the hack IME physicians out there start testifying that injured workers shouldn't get surgeries because they tend to have poorer outcomes than in the general population. Well, why? Well, it starts with the initial authorization for diagnostic testing. So again, Washington is far behind our sister states. It is embarrassing. Our legislature is not doing its job. There is no good reason you can articulate why you won't agree to the expert opinion of a treating orthopedic surgeon when they say somebody needs an MRI. We have to change the law because the law is abusing people. It's abusing the least among us, the most likely to be powerless. We therefore have to change the law so that we presumptively approve diagnostic tests that cost, and I would agree to go with what New York went with in 2007, 13 years ago. If it costs less than $1,000, it should be presumptively approved.